Hello and welcome to this Brick Court Chambers podcast. My name is Tim Lord and I'm here with colleagues from Chambers to discuss the Privy Council decision in Credit Suisse and Ivanishvili, which was handed down towards the end of last year. This was potentially a truly landmark judgment in English civil and commercial law. Why? Well, English commercial law is all about the sanctity of contracts and holding people to their bargain. But another cornerstone is the maintenance of the integrity and in particular the honesty in commercial dealings. To quote the famous dictum of Law Justice Steyn in the case of First Energy and HIB, he said this: "A theme that runs through our law of contract is that the reasonable expectations of honest men must be protected. It is not a rule or a principle of law. It is the objective, which has been and still is the principal moulding force of our law of contracts." The importance of the law of misrepresentation in sustaining integrity and the honesty of commercial and mercantile bargains probably needs no explanation. The English common law has no overriding duty of good faith. Integrity instead is protected in the case of misrepresentation by giving redress to parties who are misled by their counterparty into entering a contract, and especially so if there has been dishonesty and deception involved. In other words, fraud. Misleading and deceiving people in commerce takes many forms, not just express misstatements and lies, but more subtle and stealthy means, such as nods, winks, gestures, and other conduct, which can all in context mislead or trick someone. In Credit Suisse and Ivanishvili, the Privy Council looked at the test for reliance in the English law of misrepresentation, including fraudulent misrepresentation, in other words, deceit. As this panel will explain, the test for reliance has been reformulated by the Privy Council with significant potential implications, not least for claims for implied misrepresentation. I know the sense of excitement must be getting unbearable. Time to cut to the chase and hear from my colleagues. The following panel members: Fred Hobson KC, Lawson and Ben Woolgar. All three are very highly regarded counsel practicing in the field of commercial and financial disputes, both litigation and arbitration, including cases of serious commercial fraud. They are all particularly well qualified to discuss the Privy Council judgment, as they have all appeared with me in recent years in the high-profile first instance decisions of the English courts, which the Privy Council consider and in some respects disapprove of. Modesty prevents them from saying that their submissions seem now to have found favour with the highest appellate court, and a degree of quiet professional satisfaction should be excused. First, could I turn to you, Ben, and ask you to outline briefly the key facts in this Privy Council judgment.
Thanks, Tim. Mr. Ivanishvili is an extremely wealthy Georgian businessman, often said to be the richest man in Georgia and a former Georgian Prime Minister. Mr. Lescaudron worked for the bank formerly known as Credit Suisse, focused on high-net-worth Eastern European clients. Mr. Ivanishvili had been a client of Credit Suisse since 2005, and Mr. Lescaudron had been his relationship manager since 2006. In 2005, Mr. Ivanishvili had established a trust on the bank's advice and deposited just over $1 billion of assets into it. In March 2011, Mr. Lescaudron visited Mr. Ivanishvili in Tbilisi, in Georgia, and proposed that he should invest in a type of life insurance policy called an LPI policy with a subsidiary of the bank, which is referred to in the judgment as CS Life, and which was ultimately the defendant in the litigation. The essential point to understand about LPI policies is that they were not conventional life insurance policies of the type that any of us might take out at all. They were essentially a wrapper for existing investments with the bank, by which a wealthy client could take advantage of various tax and inheritance planning advantages by placing those assets inside a life insurance policy, which would obviously ultimately pay out on their death, or if assets were withdrawn prior to that point, as in fact happened in this case. Mr. Ivanishvili and his trusts duly invested $480 million in one policy with CS Life in November 2011, and a further $275 million in December 2012. And a critical feature of the policies that the first instance judge found and the Privy Council relied on was that they were to be managed discretionarily by a particular team within the bank called the Max team, on the basis that that team had particular expertise in investing the type of underlying financial assets that were contained inside this LPI policy. In 2015, following some margin calls against his assets, Mr. Ivanishvili discovered that Mr. Lescaudron had been committing an extremely long-running fraud. The fraud had a number of important features, most notably for the purposes of the judgment that Mr. Lescaudron had been making investment decisions himself, rather than them being left discretionarily to the Max team. And indeed, it's not clear that the Max team had any idea about these life insurance policies at all. He had also been forging documents, executing investments for the purpose of obtaining unlawful secret commissions, selling assets at an undervalue, directing their purchase at an overvalue, transferring assets to other clients, and just about every species of fraud that one can imagine a bank executive engaging in. In 2018, Mr. Lescaudron was convicted of criminal offences in Switzerland and was sentenced to 5 years imprisonment. It's worth saying that the Privy Council, and in particular Lord Leggatt, took a rather dim view of CS Life's conduct of the litigation overall, describing it as having adopted a flat-earth defence of requiring the plaintiffs to prove the underlying fraud, even though Mr. Lescaudron had admitted it himself and gone to prison for 5 years for it, and described, I think at one point, realism as not having been a feature of CS Life's approach to the litigation in relation to another ground of appeal that had been struck out by Christopher Clark of this parish in the Bermuda Court of Appeal as an abusive process. The claims were brought before the Bermuda courts, as that's where CS Life was incorporated. And I think there are 3 points just briefly worth making about the procedural context for the findings that we're about to discuss. First, the plaintiff's primary claim was actually a breach of contract and breach of fiduciary duty claim, on the basis that CS Life had not managed the policies on the discretionary basis that those policies required. That claim succeeded, and the Privy Council spends much of the judgment rejecting a number of grounds of appeal in relation to it, in particular the rather ambitious ground that the policies said they were to be discretionarily managed, but that was not a contractual obligation, which got very, very short shrift indeed. There was, however, a very limited reversal in relation to the breach of contract claim, which concerned the start date for the assessment of damages, and about $58 million allegedly turned on that start date in the context of a total claim for over $600 million. But had the board not reversed the courts below on that limited point, the misrepresentation claim would have been academic, and indeed it's possible that the Privy Council would not even have decided these issues, though one rather senses from the judgment that Lord Leggatt was chomping at the bit to decide them either way. Second, in Bermuda, the principle of double actionability applies to tort claims. That's the principle that a tort committed in a foreign jurisdiction must be actionable under both the law of the forum, i.e. Bermuda, and the law of the place where the tort was committed, i.e. Georgia, as the place where Mr. Lescaudron had met Mr. Ivanishvili and therefore made the implied representations. That rule hasn't been part of English law for 31 years. But the Privy Council ultimately upheld the conclusion of the courts below that the misrepresentation was time-barred under Georgian law, and so all of this legal excitement made Mr. Ivanishvili no further money as a result of that Georgian limitation period. Third, the case was argued on the basis that the law of Bermuda and the law of England were the same, though perhaps somewhat surprisingly, the Privy Council did not make what's called a Williers and Joyce direction, that its conclusions were to be binding before the courts of England and Wales. So perhaps a particularly ambitious defendant in some subsequent case will suggest that the findings we're about to discuss don't bind a first instance judge in England.
Thank you very much, Ben. Fred, please could you perhaps explain the way in which the Privy Council analysed the test for reliance and reformulated it?
Thanks, Tim. The decision is of enormous consequence to the test of reliance, especially, as you mentioned, the case of implied representations. Now, it's worth starting with how the law stood before the decision to then see what's changed. Now, just to set the scene, pretty basic, but a false representation can only found a claim if it induces the claimant to act to their detriment. And reliance is essentially getting at a causal connection between the false statement and the claimant's conduct. So the false statement needs to have some impact on the claimant in order to give rise to a claim. Now, when it comes to express representations, reliance tends to be fairly straightforward. Typically, the claimant will be aware of the false statement in order to say it's had some impact on their mind. So to take one of the examples given in the cases, if you're on a Zoom call and the defendant makes a full statement, but your Wi-Fi gets cut out so you never hear the full statement, it can't be said that you've relied on that statement. But of course, it's not just express statements that found claims in misrepresentation. It's increasingly common for claimants to plead an implied representation based upon the defendant's conduct. And the classic example, certainly in financial mis-selling cases, is to say that by putting forward a transaction, the bank implicitly represents that it's acting honestly. And that's essentially the foundation for the well-known libel mis-selling claims, and it's essentially the representation which was held to exist in the Credit Suisse decision. Now, where there's an implied representation based on conduct, the claimant will typically give no thought to what is being represented. So in the example I just mentioned, the counterparty realistically is not going to consciously think to him or herself, the bank is representing to me that is acting honestly. It's something the counterparty is simply going to assume.
And Fred, the Spice Girls case that ended up in the Court of Appeal would be another example of that, wouldn't it?
That's exactly right, Tim. So in the Spice Girls case you mentioned, the Spice Girls took part in a promotional photo shoot to advertise scooters. And by doing so, it was held that they impliedly represented that no band member was intending to leave the band. In fact, I think it was Ginger Spice who was about to leave the band.
It was, Fred.
That's good, Carla. Thanks for confirming.
Excellent.
It was on that basis a false representation. But again, no one at the scooter company was thinking to him or herself, the band is hereby representing to me that no member is about to leave. Again, it's simply something they assumed. And again, we see the famous example from the DPP and Ray case of a customer who sits down to order food at a restaurant. And by doing so, they implicitly represent that they intend to pay for their meal and not do a runner. And a similar sort of example was picked up by Lord Leggett in the Credit Suisse decision. If you hail a taxi, you implicitly represent to the taxi driver that you intend to pay the fare. So again, the waiter and the taxi driver aren't thinking to themselves, the diner or the passenger is implicitly representing they intend to pay. It's something they assume without giving the matter any thought one way or the other. Now, in the last decade or so, before the Credit Suisse decision, the courts had tended to say, in order to establish reliance, the claimant needs to be aware of the implied representation. And that typically meant having to give conscious thought to the representation, although there was some suggestion it could be, quote, quasi-automatic in the case of a very simple representation. Now, this awareness requirement took hold as very much the dominant view in the commercial court, in a line of cases such as Marmay, Leeds City Council and the Loreley case. And Tim, as you mentioned, each of us here has been involved in at least one of those decisions. and as I think we've all experienced, that awareness requirement tended to be a fairly formidable obstacle standing in the way of claims based on an implied representation. So that's the lie of the land before we come to last November's Credit Suisse decision. And reversing the earlier line of cases, Lord Leggett very significantly held that there is no awareness requirement. And in the reformulated test, he explained that reliance has two aspects to it. First, the representation must cause the claimant to hold a false belief. And second, the claimant must act on that belief. And Lord Leggett explained that it's a normal feature of human life that people form and act on beliefs without any conscious awareness or thought.
So Fred, going back to the example of the passenger who hails the taxi but has no intention of paying, how does reliance work on Lord Leggett's analysis?
Well, that's actually the key example which Lord Leggett gave to illustrate his new test. So Lord Leggett posited two taxi drivers, one who consciously thinks to himself, the passenger is implicit.
Is it Sherlock and Holmes?
That's exactly right. Well, I forget which is which when we got the Holmes and the Watson. So one of them, they're thinking to themselves, the passenger is implicitly representing they can pay. But the other, much more realistically, simply assumes that to be the position without giving the matter any thought. And Lord Leggett explained that both are equally the victims of deceit. In both cases, the passenger's conduct has caused the taxi driver to hold a false belief, namely that the passenger intends to pay the fare. And importantly, it doesn't matter that that false belief is an assumption on the part of the taxi driver. It's a mistaken assumption caused by the passenger's conduct. So in Lord Leggett's analysis, it all comes back to the key causation question. Is the claimant's false belief caused by the representation? So returning to the facts of the Credit Suisse decision, which Ben outlined, Lord Leggett held that by proposing the life policy and putting that forward to the customer, the bank induced the customer to believe that the bank intended to manage the policy honestly. And reversing the Bermuda Court of Appeal, Lord Leggett held that the customer could show reliance without needing to plead or prove conscious awareness.
Thank you, Fred, very much. Kyle, I think it's widely acknowledged that this judgment is likely to have a profound effect on claims for misrepresentation, including fraud. I wonder if you could perhaps outline some potential ramifications.
Yes, of course. I mean, there's obviously a big question now about how does the claimant go about establishing what assumptions they made, or how does the defendant go about testing it, particularly where these are, as it's clear from this case, they can be subconscious or unconscious assumptions. How do you actually test that practice? I think there's a couple of things we can say, offer a little bit of guidance. One point that's quite interesting to note is the test for whether a representation or implied representation was made now seems to be actually quite similar to the test for whether the claimant relied on that representation. Those two tests seem to be quite closely aligned. So if you're looking at whether the representation was made, it's very well established. You ask what a reasonable person would have inferred or assumed as a result of what the defendant said or did, so based on their words or conduct. That's the helpful test from Keystone 5, so it's the property alliance case in the Court of Appeal and so on. It's all very well established. But what's interesting about the Credit Suisse decision is Lord Leggett seems to say that for the purposes of testing reliance, the court can also ask itself whether the assumption in question was one that a claimant would naturally be expected to make in response to the defendant's words or actions. So, a lot of similarity.
Similarity there, isn't there?
Exactly. I mean, if that's right, that has some important consequences. I mean, it would seem to make the test for reliance, at least in relation to implied representations or representations by conduct,
an objective, or at least a quasi-objective test. So putting it a different way, if a reasonable person in the claimant's position would naturally have made the assumption that we're talking about, the assumption in issue in the case, then the court may quickly be able to infer that the claimant in fact made that assumption. That's just a reasonable thing for them to have done. The other consequence is that if you've already crossed the threshold of establishing that an implied representation was made, it's the natural consequence of the defendant's conduct. It's unlikely to be very difficult to establish that you relied on that assumption. The two almost, or may sometimes, go hand in hand. So both of those points are obviously likely to have quite significant implications in terms of what's required by way of evidence and proof in a claim like this, or deceit claims or civil fraud claims. And you can see that on the facts of the Credit Suisse decision. Obviously, Ben and Fred have obviously outlined that the claimant, in principle, succeeded, subject to some limitation issues on their claim. But what's interesting from the judgment is that it's clear that, although this is a fraudulent misrep claim, Mr. Ivanishvili hadn't actually given any evidence at trial that he had understood Credit Suisse to be making any implied representations to him, hadn't been consciously aware of that. He didn't even give any evidence about what his assumptions were, that he'd just assumed things as a result of their conduct, and his claim still succeeds on reliance. And that's quite a striking result.
Yes, although I suppose it could be said that the law can safely proceed on the basis that the claimant is an honest businessman or woman, and if an honest businessman or woman would have that belief or assumption, it's perhaps not such a stretch to proceed on that basis.
I think that's right, and I think there's a distinction actually between. There's clearly going to be a distinction between simple and more complex representations. So the example you give is a fairly simple representation. By putting forward this transaction, the bank impliedly represents that it's going to deal honestly with the claimant. And that's obviously very similar to what was alleged in the LIBOR rigging cases. You've got a panel bank that at the time was responsible for setting LIBOR, and it puts forward a transaction, an interest rate swap that uses the LIBOR interest rate. It goes without saying, Court of Appeal and PAG found that they impliedly represent that they won't be rigging the rate under the table if they're going to do that deal with you. I mean, at their core, these are just representations of basic honesty in commercial dealing. And I think if you've got a simple representation that's quite intuitive like that, it probably is quite easy to establish that someone would naturally assume that's what would happen, and therefore their state of mind will be affected, influenced by the defendant's conduct. It's probably going to be a bit more difficult if you're trying to engineer something more complex, a sort of more involved implied representation. The burden might be higher in terms of what you have to prove.
And Carl, would a claimant at least have to establish that they were aware of the conduct by the defendant, which is said to give rise to the implied representation? Would that be, in effect, a minimum requirement for proving reliance?
Yeah, I expect that's going to be the search for defendants. What's the bottom line here? What's the least that the claimant has to establish? I think that's right. In some cases, it's probably going to be right that the claimant has to at least show that it was aware of the sort of origin of the implied representation, the thing that gives rise to it. You can see that in the DPP and Ray case, the waiter example. So if the waiter doesn't even know the customers come into the restaurant, doesn't even see them come in, it's difficult to see that they can really infer or assume anything about this customer. It doesn't really make sense. But it's clear from the Credit Suisse decision that's not going to always be the case. They absolutely say that categorically. And they give the example of Gordon and Seleco in the Court of Appeal. It's a well-known case in the 1980s where the seller of a flat deliberately covered up some dry rot and was held liable to the buyer for deceit. So in that case, the relevant conduct that gave rise to the implied representation that there wasn't any dry rot in the flat is found to be the act of covering up the problem. Now, of course, that's the very thing that the claimant had no idea had happened. It has no awareness that there has been that conduct which gives rise to an implied representation, but the claim in deceit still succeeded. And Lord Leggatt treats that as a correct decision on its facts. So there may be cases where it's not even necessary to establish knowledge of that underlying conduct. I think the key takeaway is obviously the reformulation of the test that Fred's described, obviously going to make my life much easier for claimants. considerably simplifies what we require in terms of pleading and evidence. And Fred's already said, but basically, I think likely to reinvigorate claims based on implied representations, which have struggled in recent years, and some people dismissed as a lawyer's construct and disparage them in that way. But Leggett's analysis gives real ballast to those claims.
Thanks very much, Kyle. Perhaps we could just conclude with some unresolved issues which are thrown up by the Privy Council judgment. Fred, where does the Credit Suisse decision leave the line between misrepresentation and non-disclosure? Because I know that is going to be a heavily considered and debated point arising from this judgment.
That's fair to say, Tim. So the starting point is that commercial parties generally owe no duty of disclosure. So mere silence can't found a claim for misrepresentation. Something positive has to be said or done. And that dividing line is firmly embedded in English law and actually stands in notable contrast to the position in civil law jurisdictions where contracting parties may well owe a duty of disclosure. Now, in the line of cases such as Leeds and Marmay, the courts held that the awareness requirement served a gatekeeping function in order to separate misrepresentation claims from mere non-disclosure claims. In the case of an implied representation, the claimant's core complaint is your conduct led me to believe one thing and you never told me the true position. And Lord Leggett, in the Credit Suisse decision, acknowledged that the line between misrepresentation and non-disclosure is not always an easy one. And on his analysis, what marks out an implied representation from non-disclosure is that the defendant has actively done something so as to give rise to the representation. For example, sit down at the table or hail a taxi. Now, picking up on what Kyle mentioned, typically the claimant will be aware of the defendant's conduct that gives rise to the representation. But as Kyle mentioned, at least in some situations, the claimant can rely upon an implied representation, even where the claimant is unaware of the defendant's conduct. See the Gordon-Selico case that Kyle mentioned. And so that's an example where there is deceit, but of course the buyer in that case is unaware of the seller's conduct, i.e. the steps taken to cover up the defect. And that, it seems to me, is an example of where the dividing line between misrepresentation and non-disclosure can start to get somewhat blurred. And I think it will be interesting to see in future cases how that dividing line holds up.
Yes, and sort of picking up on that theme, will putting forward a transaction and sitting down at the negotiating table across the counter, as it were, from your counterparty, will that carry with it various implied representations? Because that was sort of what's happened in some of the market cases. Some of the LIBOR rep, for example, was essentially born of the bank just putting forward a particular transaction where that benchmark was integral to the transaction.
Absolutely. So I think that's exactly the point that future cases are bound to be focusing on. And we see that Lord Leggett saying there has to be some kind of positive conduct, but as he mentioned him, the conduct could be as simple as emailing a transaction prospectus. It could be very simple indeed.
Thanks, Fred. Ben, what does this decision mean for a case where a system, especially a computer system, is set up to rely on representations and produce outputs without any actual human person being involved?
So I think one obvious oddity of the test postulated in Loreley, Leeds, Marmay, etc., was that if there was a requirement that the representation be actively present to the mind of some natural person, then a claim in deceit would fail where the claimant operated a computer system or indeed any other sort of system for reaching decisions about when it would contract. And that was true equally in a case of an express representation, actually, as an implied representation, and was one possible flaw in the analysis in those cases that Lord Leggett identifies in the Privy Council. So take a very simple case of a bank which asks for various pieces of information before approving an application for a loan, and approves the loan and pays out the money if certain information is uploaded to a website or a particular box is checked on a website. One would think that any sensible system of law would give the bank a claim in misrepresentation if that was done dishonestly by the borrower, even though the money flows without anyone at the bank ever thinking about it. Now, in such a case, obviously, no natural person ever considers the representation, but the courts had repeatedly held that a deceit claim would nonetheless be made out in such a case, going back at least to a 2007 decision called Renault and Fleet Pro, a case about literal used car salesmen. It isn't clear that even in a pre-Ivanishvili world, the courts would actually have denied such a claim involving computer-based reliance, but they would, of course, have had to find a way to square the circle between the Renault line of cases and the Lauralie Marmé line of authorities. In any event, such an argument now seems to be a dead letter as regards express representations. As regards implied representations, there will, I think, be a difficult question about what assumptions a computer system makes, because obviously a computer system doesn't make assumptions in the same way as a natural person, and we may find ourselves interrogating lines of code and so on to see what a computer system might care about and what it doesn't, at least in more complex cases. That's likely to be very helpful to claimants in proving reliance in the new era of insurance companies, banks and investment firms and so on, relying on artificial intelligence rather than human processing. Two perhaps slightly more interesting and difficult areas.
Even more interesting,
so of course, are first cases where there is no computer, but there is some other sort of system for approving a particular type of contract or payment. In the Scat Danish tax fraud litigation, Mr. Justice Andrew Baker referred to this as systemic reliance. So that was a case where applicants for withholding tax refunds submitted a series of forms to the Danish tax authority, and there was a single man based in Jutland whose job was to stamp the forms appropriately and then cause money to be paid out, but he never thought about the relatively elementary implied representations on which that claim relied. Now, on the facts in Scat, an argument of systemic reliance failed because the judge held that the relevant authority had effectively no interest at all in its system for ensuring the honesty of the tax refund applications, though it's notable that that case was decided just before Ivanishvili and is now on its way to the Court of Appeal, which may have to resolve some of those questions. The second area that I think is likely to produce some relatively immediate reconsideration of some of the authorities is claims under Section 90 of FUSMA, where a claimant alleges reliance on a false statement in a prospectus in connection with the sale of securities. There's at least one case, Allianz and Barclays, that has held that a claimant relying on such a misleading statement cannot use what's called price reliance. So that is an argument that the misleading statement fed into the market price of the security and they purchased the security on the strength of that market price, in effect because it was said that the test under Section 90 FUSMA is the same as or is very similar to the common law test for reliance. And that, I think, will obviously be ripe for reconsideration, and especially given how much securities trading these days depends on AI, automated processing, and the hedge funds have been way ahead of the rest of us on this sort of electronic trading. One imagines that will be a particularly important area. Similarly, where the AI is capable of reading 100 share prospectuses and comparing them in ways that no natural person was ever able to do. So I think the simultaneous growth of LLMs and AI and this change in the law is likely to provide a lot of fertile ground for reconsideration.
Thanks, Ben. Kyle, misrepresentation generates a number of potential remedies. The most obvious one is rescission, which is obviously where this component of reliance or inducement comes in at that sort of anterior stage. But another potential remedy is obviously damages for loss, which you may be able to claim either in lieu of rescission or in addition. And certainly traditionally, it was thought that the requirement for causation for loss for damages was a distinct and separate exercise and inquiry to that for reliance or inducement at the earlier stage. Just wonder if you had any thoughts on how the Credit Suisse judgment may bear upon that debate.
God, ask me an exam question there. It's a good question. It's obviously you're right that it's sort of in theory and in the textbooks there's separate tests for reliance and causation. As Fred said, essentially the effect of this decision is to say reliance is all about causation and the impact that a representation had. But technically there is this separate element to look at. There's obviously lots of cases on that. It's not addressed in this decision in any detail. We'll have to see how this is worked out. But yes, in theory, a claimant still has to prove, even if they get over reliance, they have to prove that the representation caused them some loss. It's now pretty well established that that means asking what would the claimant have done if the representation had not been made to them, not what would the claimant have done if they had been told the true position. That's in principle. But obviously in practice, it's sometimes very difficult to apply that test, particularly in relation to implied representations. And that's another point that comes up in the SCAT judgment of Andrew Baker. So where you've got a representation that is implicit in what the defendant has said or done, it often doesn't really make any sense to say, well, what would have happened if that representation had never been made? Because they said the thing they said, they did the thing they did, and the representation was made. It's a nonsensical question. The only way of avoiding that is either the defendant could have disclosed the true position, that would have stopped the representation being made, or they could have not entered into the transaction with the claimant at all, which obviously has significant implications for rescission and damages claims. It's another point that's well illustrated by DPP and Ray, the waiter example. It just doesn't make any sense to ask what would the waiter have done if the diner hadn't made the implied representation about being willing to pay. That's inherent in the conduct of sitting down. So you could only avoid that representation by sitting down and explaining, by the way, I don't have any money, or not coming into the restaurant at all. And the question is, well, what would the waiter have done? And most restaurants we've been to, the waiter would have had a stern word and told you where else you could go. But it's obviously very context dependent, and it very much depends on the nature of a particular case and the representation alleged. But it's another point that'll have to be worked out in other cases.
Thank you, Kyle. In conclusion, it is worth remembering where we started this podcast, namely as to the importance of honesty as a fundamental cornerstone of commercial dealing, which the English law of contract holds dear. Every lawyer knows of the caveat emptor principle, i.e. buyer beware. However, that can only operate so long as there is no actionable misrepresentation or deception involved. There has always been a tension in the law between contractual certainty and party autonomy, on the one hand, requiring respect for the bargain struck, and, on the other hand, ensuring that commercial contracts are always honestly procured. It may be said that the Privy Council judgment in Credit Suisse is a nod firmly in the direction of the importance of honesty amongst mercantile men and women in their commercial exchanges. It could also very properly be said, in my respectful opinion, that this decision strengthens the objective referred to by Lord Justice Steyn of protecting the reasonable expectations of honest people. On any view, the case is likely to spawn enormous interest and further judicial consideration. It only remains for me to thank my fellow panellists for their erudite contributions, and also to thank all of you for watching and listening, especially if you made it through to the bitter end. Thank you.